Hello everyone, my name is Aaron Woodman, and I want to welcome you to my YouTube channel. In this video, we are going to talk about your right to publish without being stopped by the government. Let's begin with the historical background. What would later become known as the Pentagon Papers began as a study commissioned in 1967 by Defense Secretary Robert McNamara. McNamara's instructions were that the report be encyclopedic and objective. He got his wish. A year and a half later, the completed study was presented to a new defense secretary. All 47 volumes and 7,000 pages compose of 3,000 pages of narrative and 4,000 pages of supporting documents. It was classified as top secret, the military's largest or highest level of national security information classification, which applies only to secrets that, if revealed, quote, could result in exceptionally grave damage to the nation, unquote. The government continued to consider the report so secret that it was not fully declassified until 2011. Daniel Ellsberg, the man responsible for releasing the Pentagon Papers, would later describe the documents as revealing, quote, a policy of concealment and quite deliberate deception from the Truman administration onward, unquote, about America's role in Vietnam. Of the most immediate interest to the country, the report showed the bombing taking place in North Vietnam was not deterring Viet Cong fighters and wasn't working to bring an end to the seemingly endless war. Floyd Abrams, a lawyer who would defend the New York Times in the Pentagon Papers case, put it simply, quote, the documents were devastating, demonstrating an extraordinary level of government duplicity based upon an unprecedented source, the very files of the government itself, unquote. Ellsberg began secretly removing portions of one of the copies of the Pentagon Papers to photocopy page by page. He brought the papers to anti-war senators, but they refused to make the documents public. Feeling increasingly desperate that the papers would never be released, Ellsberg took the riskier step of giving access to Neil Sheehan, a respected Vietnam reporter with the New York Times. A team from the New York Times soon decamped with the papers to a secret hotel suite and began a vigorous 3-month review. They would later describe their efforts as a race to absorb the information, corroborate its accuracy, and determine what could be reported without potentially compromising national security. Meanwhile, the editors, lawyers, and publisher of the New York Times began a fierce internal debate as to whether to publish or report on the Pentagon Papers at all. The newspaper's outside law firm, Lord, Day & Lord, strongly warned against it. The publisher, Arthur O. Sulzberger, was advised that publication of the top secret documents would violate the Espionage Act and that he could be jailed himself. Undeterred, on June 13, 1971, the New York Times published its first article on the Pentagon Papers with the uninviting dry headline, quote, Vietnam Archive. Pentagon study traces 3 decades of growing U.S. involvement, unquote. With this background information in mind, let's see how the government responded to this publication. Initially, Richard Nixon did not appear concerned about the publication since he was advised it would mostly reflect badly on the Democrats, but during a phone call with Henry Kissinger, Secretary of State, Nixon said that, quote, this is treasonable action, unquote, on the part of the people who put this out. Kissinger responded, quote, there's no question it's actionable. I'm absolutely certain that this violates all sorts of security laws, unquote. By the end of the call, they agreed to have Attorney General John Mitchell examine options on how to respond. The next day, after the New York Times published its second front page article on the Pentagon Papers, Mitchell told Nixon that they would look a little foolish not to take action against the newspaper. The federal government had never before in American history brought an action to stop a newspaper from publishing. Still, Nixon made up his mind by saying, quote, as far as the Times is concerned, there are enemies. I think we just ought to do it, unquote. Mitchell sent a telegram to Sulzberger stating that continued publication of the Pentagon Papers, quote, will cause irreparable injury to the defense interests of the United States, unquote, and requested that the newspaper stop publishing the information and return the documents to the Defense Department. The Times refused and published an article the next morning with a blaring all-cap headline, quote, Mitchell seeks to halt series on Vietnam, but Times refuses, unquote. The Civil Division of the United States Attorney's Office in Manhattan sought an emergency order to prevent the Times from publishing another word of the Pentagon Papers. Meanwhile, the Times was unceremoniously dumped by the law firm that had represented the newspaper for more than 60 years. This was an unmistakable sign of how radically their decision to continue publishing was perceived in some legal circles. Fortuitously, the general counsel for the Times had made a middle-of-the-night call to hire Yale constitutional law professor Alexander Bickett and up-and-coming First Amendment attorney Floyd Abrams, who eagerly took on the case and confidently told the New York Times leadership that it would obviously win. The request for an injunction had been assigned to Judge Murray Gerfen, a Nixon appointee, who was so new to the bench that this would be his very first case. The New York Times made the risky but principled decision to refuse the judge's request to voluntarily stop publishing during his legal review. As a result, Gerfen granted the government's demand for a temporary restraining order, barring the Times from publishing anything further on the Pentagon Papers. The Times then had to make another fateful decision, whether to obey the judge's order. Bickett and Abrams had two primary arguments to convince the judge that a permanent order to halt publication must not be granted. First, they made it clear that what the government was seeking was a prior restraint. This is a government action by statute or court order to prevent speech before it occurs. Second, the Supreme Court had, quote, consistently rejected all manner of prior restraints on publication, unquote, for more than 150 years. In addition, they took a broader view that the publication of government documents exposing presidential misconduct in the war was exactly the type of press action that the First Amendment was created to safeguard. In a surprising turn of events, just 3 days after Judge Gerfen had granted the temporary injunction, he ruled that he was denying the government's request to stop the publication. He found that the government had failed to produce enough facts to demonstrate a, quote, sharp clash between the vital security interests of the nation and the compelling constitutional doctrine against prior restraint, unquote. It was a resounding victory from a surprising source. Nonetheless, the judge did maintain the temporary stay on the publication while the government appealed his decision. Meanwhile, with any future publication of the Pentagon Papers by the New York Times in limbo, Ellsberg gave another copy of the secret documents to the Washington Post. The same day, the Post published its own front-page Pentagon Papers articles. The Assistant Attorney General and future Supreme Court Chief Justice William Requisite asked the paper's executive editor, Ben Bradley, to cease publication. Eventually, Ellsberg gave copies of the papers to 19 newspapers, and as the government tried to stop 4 of the publications, one exasperated judge declared they were, quote, asking us to ride herd on a swarm of bees, unquote. Bradley refused, and the Attorney General's office hauled them into court the same night, launching a new front in the government's litigation war. The separate district court wins for the New York Times and the Washington Post were both appealed and sent back to the district court for further hearings. The Times chose to appeal directly to the United States Supreme Court, which agreed to hear the case, scheduling oral arguments for June 26. This Supreme Court case was called New York Times Company versus United States. Let's go over what happened in this case. Solicitor General Erwin Griswold, representing the United States, arrived with 3 boxes holding a rare copy of the complete Pentagon Papers. He asserted that the Times and the Post had obtained the Pentagon Papers as part of a breach of trust. Griswold said, quote, "They know that this material is not theirs. They do not own it. The heart of our case is that this publication will materially affect the security of the United States. It will affect lives. It will affect the process of determination of the war. It will affect the process of recovering prisoners of war," unquote. He argued that the standard for stop and publication should not be that to continue would result in immediate harm to the United States, but rather irreparable harm. Griswold concluded that, quote, "To say that publication can only be enjoined if there will be a war tomorrow morning when there is a war now going on is much too narrow," unquote. Appearing on behalf of the New York Times, Alexander Bickett began by arguing that the president does not have any inherent power to impose a prior restraint on speech, and that there was no federal law that authorized such an action either. He emphasized that, quote, "Prior restraints fall on speech with special brutality and finality and procedural cases all their own, which distinguishes them from other regulations of speech. If a criminal statute chills speech, a prior restraint freezes it," unquote. After hearing all of these arguments, the Supreme Court held in a 6-3 decision that the government had not met the, quote, "heavy burden of showing justification for the imposition," unquote, of the prior restraint against the press. The Supreme Court also held that the injunction against the newspaper was lifted. The next day, the New York Times resumed its series, which had been halted for 15 days. Justice Black's opinion, joined by Justice Douglas, took a free speech absolutist approach, writing that, quote, "Every moment's continuance of the injunctions against these newspapers amount to a flagrant, indefensible, and continuing violation of the First Amendment," unquote. He then set forth a soaring tribute to the role of a free press. He said, quote, "In the First Amendment, the Founding Fathers gave the free press the protection it must have to fulfill its essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that the press would remain forever free to censure the government. The press was protected so that it could bear the secrets of the government and inform the people. Only a free and unrestricted press can effectively expose deception in government, and paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people and sending them off to distant lands to die in foreign fervors and foreign shot and shell. In my view, far from deserving condemnation for their courageous reporting, the New York Times, the Washington Post, and other newspapers should be commended for serving the purpose that the Founding Fathers saw too clearly. In revealing the workings of government that led to the Vietnam War, the newspapers notably did precisely that which the founders hoped and trusted they would do," unquote. Justice Stewart and Justice Wright were the swing votes that ultimately turned in favor of the Times, yet Justice Stewart's opinion, joined by Justice White, took a much less salvatory approach than Justice Black's. Stewart stated that he agreed with the government that at least some of the documents should not be published in the interest of national security. Nevertheless, sounding almost reluctant, Justice Stewart found that he could not say that the publication would, quote, "surely result in direct, immediate, and irreparable damage to our nation or its people," unquote. This phrase would later be understood as establishing the key legal test to come out of the Pentagon Papers case. It seems Bickett's bold concession that direct loss of life could trump the First Amendment not only garner him the votes needed to win, but contributed to the formation of a test that provided extraordinary, if not absolute, protection of the press. But there was a catch. A majority of justices indicated that the leakers themselves could still be criminally prosecuted. The First Amendment shield against prior restraints on the press would provide no such protection for the man who provided the top secret documents to the media in the first place. Ellsberg ultimately would be criminally prosecuted under the Espionage Act for revealing classified information. So, after this decision was made by the Supreme Court, what happened next? The Times went on to publish 6 more reports on the Pentagon Papers and received the Pulitzer Prize for Public Service in 1972. The Pentagon Papers revealed that 4 presidents had repeatedly and intentionally lied to the media and the American public about the origins, nature, and extent of the Vietnam War. What had always been a fragile and combative relationship between the press and the government had fractured in a way that would not be healed, leading these two entities down a considerably more adversarial path. On the war front, the continued publication of the Pentagon Papers did not hasten the end of the conflict as much as Ellsberg and other anti-war activists had hoped. America would not withdraw from Vietnam for another 4 years, yet they surely lent credibility to, quote, the growing consensus that the Vietnam War was wrong and legitimized the radical critique of the war, unquote. Nixon's unsuccessful fight to stop the publication of the Pentagon Papers lit a fire under his building paranoia and desire for revenge against his perceived enemies. He authorized the formation of the White House Special Investigations Units, soon to become infamously known as the Plumpers. Their first task was the burglary of Ellsberg's psychiatrist's office, and their last effort was a botched break-in at the Democratic National Committee headquarters at the Watergate Hotel. As a result, the judge in Ellsberg's trial would later drop all the charges against him after the evidence of the burglary was put before the court. Ironically, it was Nixon's efforts to stop the Pentagon's papers and leakers at all costs, not anything in the documents or press reports on them, that brought down his presidency and enabled Ellsberg to walk away from any criminal consequences. All in all, this case showed that the government cannot stop the publication of any information they do not like. As Floyd Abrams succinctly puts in, prior restraints are, quote, just not a weapon in the arsenal, unquote, of presidents and the rest of the government, thanks to the Pentagon Papers. This case established a high bar for the government to censor the press through prior restraint. Today, it means the press can publish classified information to expose government deception without being stopped beforehand, as long as the publication does not cause a direct, immediate, and irreparable harm to national security. This ruling strengthened press freedom by safeguarding the public's right to know what is going on in our government and hold them accountable. With this ruling in mind, let's proceed to a modern example of this by looking at a story of Stormy Daniels. When a photo of Stormy Daniels posing with Anderson Cooper was tweeted out by her lawyer with a simple reference to 60 Minutes, it triggered the desired effect. The media went into a frenzy of speculation about what the adult film star would say now that she appeared ready to talk about her alleged affair with Donald Trump. It had been almost 2 months since the Wall Street Journal broke the story that Trump's former personal lawyer, Michael Cohen, just days before the presidential election, had arranged a $130,000 payment to Daniels for signing a non-disclosure agreement. It seemed she was ready to speak out and be taken seriously. 60 Minutes would be the ideal place to tell your story. However, just a few days after the announcement, the conversation began to turn from when the interview would air to questions on if it would air at all. A growing chorus of media outlets were soon reporting that Trump's legal team might seek a court order to stop 60 Minutes from televising the interview. Here's the question. Was President Trump constitutionally prohibited from obtaining a prior restraint to stop 60 Minutes from broadcasting an interview with Stormy Daniels? Well, Trump's legal team began by seeking an emergency order to enforce her 2016 non-disclosure agreement and prevent her from disclosing any of the confidential information it covered. They argue that if Daniels wasn't ordered to abide by the agreement, Trump would suffer irreparable harm. As a result, a temporary restraining order was issued against Daniels, handing Trump a preliminary win. Daniels fought back with a separate legal action to declare the NDA unenforceable because Trump never signed the agreement. But before these legal fights were concluded, Daniels was set for the interview with Anderson Cooper, the broadcast of which would enable Daniels to break her agreement. Trump's legal team could still argue that a balancing test should be used to weigh privacy and contract rights against those of the press. His lawyers could contend that the potential privacy violation is usually damaging and the public interest in the material is low. After all, the argument could continue into this question: why should a media company be allowed to help someone break a contractual agreement just because the First Amendment might favor publication over restrictions on the press in some cases? However, with the Pentagon Papers precedent and the string of cases reaffirming its principles over the years, they established that prior restraints are almost always unconstitutional. It also created a legal test that does more than just balance the First Amendment protections against other valid interests. Instead, anyone seeking a prior restraint on the media needs to meet the extremely heavy burden that broadcast or publication of something would, quote, surely result in direct, immediate, and irreparable damage to our nation or its people. Ultimately, what Stormy Daniels had to say about Trump's sex life is not as important as her ability to say it, which is the main focus of this example. Whenever there is an allegation that someone in our government committed misconduct, we need to investigate the allegation by looking at the information provided to us and evaluate if it is true or false. The government cannot stop someone from explaining their allegation simply because the government dislikes the allegation. Now, all in all, if publishing top secret government documents during wartime and the resulting potential threats to national security interests were not sufficient to meet the heavy burden, it is clear that very few factual situations will have any chance of doing so. In this way, the Pentagon Papers continue to be an invaluable and often unnoticed shield for the press against government interference in their reporting. The Pentagon Papers case matters because it constrains anyone all the way to and including the President of the United States from stopping the publication of information they do not like or do not want to be heard. From Vietnam secrets to claims of sexual and political misconduct, the First Amendment continues to mean that the media's ability to speak truth to power is unabridged. No one can stand in the way of Americans' ability to see and hear information and then judge for themselves. In the next video, we will talk about not having the right to curse on broadcast television and radio. Until then, please like this video, subscribe to my YouTube channel, and turn on the post notifications so you will be notified when I post my next video. I appreciate your support. Remember, you are powerful, you are capable, and you are the changemaker our society needs. Thank you so much for watching this video. I will see you soon.